Good morning and welcome to everyone joining us this morning for the first of our spring webinars. This morning, Hourglass are very pleased to be presenting the webinar, Protecting Older People, Preventing Undue Influence with Anthony Gold. My name is Sarah Brown and I'm one of the trustees on the board of Hourglass. And for those attending who maybe haven't attended previous Hourglass webinars, Hourglass is a specialist charity working to bring an end to the harm, abuse, exploitation and neglect of older people across all 4 nations in the United Kingdom. And we are striving to create an environment, a safer aging environment where older people can grow old safely and securely, free from abuse and from harm. In the UK, it is estimated that probably around 1 in 6 older people are victims of abuse. So it's a growing problem, especially with our demographics. So now, more than ever, it's important that we raise awareness of the prevalence of abuse and ensure that people who come across any form of abuse know how to report it and to get action taken. As we know, anyone can be a victim of financial or economic abuse, but age, frailty, disability, mental capacity may increase this vulnerability. Older people are often a target for those seeking to exploit and use undue influence for a range of very unpleasant reasons. Financial and economic abuse comes in many guises, and it certainly is one of the most reported forms of abuse through to our 24/7 helpline. This morning, we're delighted to be presenting this webinar with our partners, Anthony Gold, and to have input from some very other highly respected professionals working in this field. But before I go on to ask our panelists to introduce themselves to you this morning, I just have a few housekeeping rules. As you know, this webinar is being recorded and will be available after the event. It will be forwarded to everyone who is registered for the webinar, and we would ask our attendees, if you have any colleagues or friends that you think might be interested in this webinar, to please share the link with them. The link will be available in our newsletter and across our social media fronts. And if you haven't already signed up to receive our Hourglass newsletter, I would strongly encourage you to do so that you can keep up to date with what is happening in this area. We will also be sending out after the webinar a very short SurveyMonkey questionnaire, and we'd really be so grateful if you could complete it. Only take a few minutes to do so, but we welcome the feedback that you can give us so that we can plan for future webinars in terms of improving the experience for people joining us. And then finally, and I'll mention this again at the end, but we are hosting a conference for the first time in a long time next Tuesday, the 19th of March in Brighton. And we have a very full programme. And I know Naeem will put up the link in the chat function. And it is now also possible, if you're not able to get to Brighton, to attend virtually. So I would encourage everyone to perhaps look at that and see if that's something you'd be interested in. As we go through the webinar, we'd be very happy if you have any questions that you would put them into the chat function, and we will be keeping an eye on that. And at the end of the presentations, we have a plenary session of questions and answers, and we will try to get to as many of the questions as possible. And if there's anything that we can't respond to this morning, we will follow up with you afterwards, after the close of the webinar. So if I could then, because they'll do a much better job than I could do, hand over to ask our panelists just to give a very brief introduction in terms of your name, your organisation, and then following the introductions, Tom and Lee from Anthony Gold are going to make 2 short presentations, and we'll have input from our other panelists. And then Colin will finish with 2 case studies that he would want to share with us, and then we'll get to the question and answers. So it's a very full morning, and I hope everyone comes away from the webinar feeling much better informed about this very, very complex subject area. So if I could maybe hand over now to Tom to start off, to introduce yourself, Tom. Thanks.
Thank you, Sarah. Good morning, everyone. So my name's Tom Dickinson. I'm a senior associate at Anthony Gold who specialises in contentious probate and trust disputes, and this often involves me dealing with claims relating to undue influence, whether or not this is in relation to kind of a lifetime transaction, maybe the transfer of money by someone or a property, or also in relation to a will and an argument after someone's died. So that's me, and as Sarah said, after everyone's introduced themselves, I'm going to kind of touch on some of the legal principles in a bit more detail. Thank you.
Thanks, Tom. Lee.
Hello, everyone. Good morning. My name's Lee, and I'm a solicitor in the Wills, Trust and Estates team at Anthony Gold. I help clients prepare wills lasting thousands of years. Also do estate administration. So today I'll be talking about the practical elements that solicitors should follow when dealing with vulnerable and elderly clients.
Thanks, Lee. And Jo?
Good morning. Thanks, Sarah. So my name is Jo Summers. I'm a partner in a firm called Durit LLP, and today I'm here as a spokesperson for STEP, because STEP has been doing some surveys of its members recently on the very topics we're discussing, and I've got some of the key responses, some of the key issues that have come out of that survey to cover very briefly later.
Thanks, Jo. And Tish? Tish, you're on mute.
I do apologize. That was a great introduction. The number of times I've done this, I'm sorry, everybody. I have a cough, so I've been muting myself most of the time. Good morning. Yeah, my name is Tish Hannafin. I'm the founder and the joint chair of an organisation called the Society of Later Life Advisors, which is SOLAR. It's a not-for-profit organisation, which I founded specifically to help consumers find the right kind of specialist later life advice.
Thanks, Tish. And Colin?
Good morning, I'm Colin Scott. I am the Community Response Coordinator with Hourglass, based in Scotland and Scotland and Northern Ireland. Our frontline work, working with older people at risk of or experiencing harm and abuse in its various forms.
Thanks, Colin. And so we'll start then this morning off with Tom's going to start off with a short presentation. Over to you, Tom.
Thanks, Sarah. I'm going to attempt to share my screen, so bear with me. So I've been asked to take you on a whistle-stop tour of just some of the legal principles of undue influence, and also some of the kind of factors and things that I would look out for when assessing a claim, and things that the court over the years have kind of demonstrated that they would place weight on when they're kind of deciding a claim for undue influence. So, as I'm sure many of you know, undue influence is it's what we call a cause of action, or a type of claim through the civil courts for seeking to set aside a transaction or a legal document. For example, a lifetime gift or transaction like the transfer of money or a property, a contract if someone's entered into that, and also a will, and that's a very common thing that happens after someone's passed away. If undue influence is proved to the court, then the usual remedy is that the transaction affected, or the document, is set aside and the parties restored to their original position. So in practical terms, that might mean money being ordered to be paid back, or a property being ordered to be transferred back into someone's name, or in relation to a will, it might be the court declaring that will invalid and the position being restored to what it would have been before that will was put in place. There are two types of undue influence in law, and I appreciate this kind of might now get a bit complicated, so bear with me. I'm going to explain these kind of two distinct types in a bit more detail in the next few slides. But there's the first type is called actual undue influence, and the important point is that actual undue influence is the only thing that can be claimed in relation to a will, and as will become apparent, it's a much more difficult thing to prove. The second type is presumed undue influence, which can be claimed into in relation to things like lifetime transactions, transfer of money, property, if someone's severed a joint tenancy, anything like that. And that's a much easier thing to establish and to succeed on. So if you possibly can, that's the kind of ground and the type of undue influence you want to claim. I've put the difference, kind of quote there from a case called Drew and Daniel, which kind of explains the difference. I'm not going to read that out, but it's there for reference, and I think it's quite helpful because, as I said, I'm going to kind of touch on the difference in the next couple of slides anyway. So starting with actual undue influence, and as I said, this is the only type that can be claimed in relation to a will. What you essentially would have to prove to the court is that there's been a level of coercion so high that the gift giver, the will maker, is no longer making the decision for themselves. And that kind of level of coercion was described by Mr. Justice Lewison in a famous case called Edwards and Edwards, and this is kind of a famous quote that she used to explain this kind of level of coercion. I'm not going to read it all, but as you'll see, it's described as pressure that overpowers the volition without convincing the testator's judgment. It is to be distinguished from mere persuasion or appeals to ties of affection. So what you really need to prove is coercion so extreme that you're essentially making someone do something against their own free will, without convincing them that it's actually what they want to do. They're kind of aware it's not what they want to do, but they feel forced to do it anyway. And it's much more than just kind of badgering someone or trying to pull on their heartstrings or trying to persuade them and get in their ear. It's kind of a much more extreme level than that. And the burden is very much on the person making the allegation to prove that to the court. And because of the very nature of what you're trying to prove, it's unlikely there's going to be much evidence, because somebody who's influencing someone in that way is unlikely to keep a paper trail of what they're doing, or is likely to have done it all behind closed doors. So it's kind of notoriously known as a very difficult thing to succeed on at court, and it's quite a rare thing to succeed on. Each case, in relation to actual undue influence, very much turns on its own specific facts and how the court then kind of assesses everything. And I'm going to kind of cover some of the factors the court will look at in a later slide. But it is quite a difficult kind of thing to predict with certainty whether or not you're going to succeed on, because it is very much down to kind of just how a judge feels about everything on the day. Presumed undue influence is much more common to succeed on. It's easier to establish, and that's because in relation to something like a lifetime transaction, transfer of a property or something like that, what you need to establish to the court is two things, which is firstly some kind of relationship of trust and confidence between the influencer and the victim, and that relationship is already presumed in certain kind of classes of relationships, such as parent-child or doctor-patient, solicitor-client. That's not an exhaustive list, and so whatever the relationship might be, if you can establish that it was a relationship of trust and confidence, then that's the first part ticked off. The second thing you need is some kind of transaction which calls for an explanation, which again is a very kind of broad, undefinable thing. And if you can prove those two things, then the burden then shifts onto the defendant, the influencer, to explain the transaction. And if they can't explain why it was done kind of validly, undue influence is kind of presumed by the court, and it will succeed. And so hypothetically, if one of my clients transferred £50,000 to my current to my own personal account, then obviously that relationship of trust and confidence would automatically be there as my client. And secondly, that would quite clearly be a transaction which at the very least I should explain. And if I couldn't explain some kind of legitimate reason for it, the court would say it was undue influence and I'd have to pay it back. So it's a much easier thing to establish than that kind of very onerous actual undue influence. So the next slide, might be the most helpful thing for you, and will be helpful when we're looking at the case studies. And this, this isn't an exhaustive list, but it's things that I would look out for when I'm reviewing a claim. It's things that the court over the years have kind of demonstrated they place considerable weight on when they're looking, assessing a claim and kind of balancing everything. And so that would be things like the vulnerability of the victim. Were they particularly susceptible to undue influence because of their health or age? The victim's relationship with the influencer. Were they in a position of kind of control or ascendancy over them? Was the victim scared of them or reliant on them in some way, for care or something like that? And then the tactics of the influencer. The common kind of things that you would see is things like isolating the victim from other family members and friends, maybe moving in with them, or taking them to live with them and really cutting them off from the outside world, so they can do everything kind of behind closed doors. And the other thing that really you would need to establish to the court, or at least try to explain, and this obviously is very difficult given that it's probably going to be not much evidence, and in relation to a will, the victim is dead, so you really are kind of fighting an uphill battle. Is you need to try and explain what method of coercion might have been used. And so ideally you might have some kind of messages or emails or something threatening, but that that's very unlikely. And what you're most likely to have is maybe the testimony of family members and friends who've been present in the company of these people, who can kind of provide evidence on how they were around each other and the things that were said. And the fourth one, again, a very important factor, was a professional or a legal professional involved, to advise on a transaction or in relation to a will. If they weren't, then that can be a very kind of persuasive factor in favour of undue influence. If they were, and they kept a very good file which showed that they kind of did appropriate safeguards and due diligence, and they did things like speak to the victim on their own without the influencer present, and that can potentially be fatal to a claim for undue influence. But conversely, if you get their file and it shows that they allowed the influencer to drive everything, arrange the meeting, attend the meeting, speak for the victim, then that that evidence can be very helpful. The next thing is the motive of the influencer, and this might be kind of go without saying, but did the transaction or will result in a financial benefit for them? This this is usually maybe the most clear-cut thing of all of them, because it's quite apparent on the face of what's happened whether or not they benefit from it. But it's not always entirely clear-cut, because, for example, I've seen situations where there might be a will which leaves something to the influencer's children, and so while they don't benefit directly from it, they do in a kind of broader sense. And the final thing, and this is very important, and this is something that the court always wrestles with, is what reasons were given by the victim or influencer for the transaction or the will. Do these reasons make any sense whatsoever, given their previous will making pattern, or their pattern of making payments to people, or things like that before? Is undue influence the only logical explanation for why something has been done in this way? And so again, that's not an exhaustive list, but those are certainly some very kind of key factors that should be looked into when looking at these claims.
Thank you. Thanks, Tom.
And just fine, sorry, Sarah. Just finally, and this segues into Lee. I was asked very briefly to just touch on the difference between undue influence and lack of mental capacity, and the only point there is that there is a crossover, because, as I said, the health and vulnerability of somebody is kind of relevant to both. But the point is that they are distinct claims, and that somebody can be unduly influenced whilst having no issues at all with their health or mental capacity. And these are two distinct things that a kind of non-contentious private client solicitor like Lee would look into separately when he's advising someone, and which he'll speak about now. So I will stop sharing my screen and be quiet.
Thanks, Tom. I think that has given us a lot of food for thought, and we'll pick up, I've no doubt, some of those points that you've raised later on in the webinar. And if we pass over, Lee, to yourself.
Let me unmute myself. Let me just share my screen. Can everybody see that?
Yes.
Perfect. Okay, so thanks, Sarah, and thanks, Tom. Tom, well done on condensing all that information about undue influence. That was really useful. And as a solicitor, I'm often instructed to assist elderly and vulnerable clients with wills and lasting powers of attorney. Some of these clients may be suffering from conditions which may impact on their mental capacity, and these clients are also at the greatest risk of being coerced in making decisions they do not freely wish to make. As solicitors, there are certain rules and procedures that we should follow in order to reduce the risk of a possible negligence claim or challenges against the estate. So when we are dealing with elderly and vulnerable clients, and there's an issue with capacity, we should always follow the golden rule, which recommends that an appropriately qualified person should carry out a mental capacity assessment, confirming that the client has capacity to provide instructions. Secondly, if the client has an existing will or lasting powers of attorney, then it is important for this to be discussed with the client at the meeting and then go through the changes the client would like to make and their reasons for doing so. And thirdly, the client should always be seen alone with the solicitor. And if the client requires support, then that is given by somebody fully independent and doesn't stand to benefit from the will. So whilst solicitors should exercise more caution with elderly and vulnerable clients, all clients should be treated the same. So although a decision may seem unwise on the face of it, it is not necessarily an indication of incapacity. So a client may have perfectly valid reasons as to why they are making decisions they are making. In this instance, a solicitor has a duty, therefore, to ensure that the client is making decisions freely without coercion and fully understands the impact of their decision. To understand the impact of their decisions, a client must show these three things. So firstly, they must understand the information relevant to the decision. So do they understand the purpose of a will, for example, the role of an executor, or what a beneficiary is? Secondly, can the client retain it for long enough to make a decision? So can they comprehend the information given to them to formulate decisions, or do they have difficulty recalling the information provided to them? And thirdly, do they understand the consequences of making or not making a decision? So it is important overall to treat all clients the same and be sensitive and understanding of their decisions on a case-by-case basis. So as mentioned earlier, elderly and vulnerable clients are at the greatest risk of being coerced, of making decisions. So the red flags that should signal to a solicitor of a possibility of undue influence include a situation where a client has made changes to their wills, and those specific changes represent a significant departure from their previous wishes. So i.e., if they start favouring one beneficiary over the other, when initially they were equally provided for. Secondly, the presence or arrangements of for will were made by a person who stands to benefit from the proposed change in the will. In this instance, I would always verify with the client directly the instructions given by that person. And finally, where the client's personal circumstances, including their age or medical conditions, make them particularly vulnerable. So in order to reduce the risk of a challenge for undue influence against the estate, it is important that robust processes are followed by the solicitor and detailed attendance notes are created and that careful considerations are made by the solicitor. Thank you. That completes my presentation, and I welcome any questions at the end.
Okay, thanks, Lee. And if we pass over now to Joe.
Yes, hello, thank you. I'll try and share my screen, which is to be interesting by the looks of things. Here we go. I think that's the right thing. Right. Okay, can you all see that okay?
Yep.
Great.
Yes, that's perfect, yeah.
So STEP is very interested in this area for our members, and we've been collating, trying to get feedback from our members from around the globe, not just in parts of the UK, but from members globally. So we sent a survey to STEP members in June and July of last year, and we got 756 responses from 44 countries. So it's quite interesting, the variety of places that it covered. And what we found is quite concerning in some respects. We found that more of our members are finding capacity issues or requests for advice on capacity issues have been increasing. And 83% of our respondents felt that this would continue over the next 5 years. So capacity is becoming more and more of an issue. And that's partly because of the aging population. There are some statistics on how many of the globe is going to get bigger, and apparently it's going to be going up to 22% of adults are going to be over 60 quite soon. So it's going to be more prevalent for all of us. What's even more concerning is that so many of our members have seen financial abuse increasing, particularly for older or vulnerable clients. And the majority of the respondents had seen financial abuse or suspected it in the last 2 years, and 40% thought that that was going to continue to get worse. So very concerning picture for our members on this area. The other thing that it picked up is that capacity is a complex issue, as we've heard. It's often hard to assess. I mean, how do you assess whether a client has got capacity? And there's a variety of answers from people as to whether they insist on a capacity check every single time, or whether they only do it if they have personal concerns or questions that they think this person they are meeting needs to have a capacity test. With COVID, there was a sudden increase in virtual capacity assessments, but there are large concerns amongst the members that this isn't as robust as an in-person one, although it might be easier to get somebody to sit in front of a computer than to get them physically in front of a person to have a capacity test. And although we're used to having lasting powers of attorney or enduring powers of attorney here, there aren't those legislation doesn't exist in many countries abroad. So STEP is going to be working with local members to try and support other countries in getting that legislation. But certainly in the UK, we've noticed an increase in LPAs being requested, both types, health and welfare and finance and property. And the other thing that comes up a lot for our members is how difficult it is to have an LPA or an EPA in place in one country and then have that recognised in another country where there might be, the assets might be there, they might have a holiday home in Spain, for instance, or something like that. So that's the other point that came up quite clearly. So the recommended next steps, as I said, we're trying to make sure that global legislation is in place, that those places that don't have LPA type legislation do get it, and then we're trying to support so that it is standardized as far as possible by showing what's best practice in other countries. We are trying to see how we can help safeguard against abuse, and that's partly going to be through education. But we are very concerned that 64% of our respondents felt there isn't enough monitoring of attorneys and deputies, and 59% felt there was a lack of public awareness that this is a big issue, that financial abuse of elderly people exists. So we've got an advanced certificate in advising vulnerable clients, so that can be done if you're interested in getting more education. We've also got a mental capacity special interest group that you can join if you're interested in this area, and there you can share your experiences and your knowledge with others, and hopefully gain back as well from their knowledge as well. So that's what STEP is doing in this area, and it's really heartening to hear that this is what Hourglass and Solo are doing as well. Thank you.
Thanks, Joe. It's very useful. And if we go over, Tish, to yourself. You have to unmute. Tish.
For those of you that have logged on to hear someone, I'm so sorry. It's not as though I don't do this often. Just been trying so hard not to cough through this. Yes, thank you. It was very interesting to hear my fellow panelists and what they've said. I would just like to make a few just observations really about the things that Solar have seen that really support what's been said this morning. I mean, I was just listening to Joe's comment about the 59% people lack of public awareness. I think that financial advisors are in a really good position to help to stamp out financial abuse, obviously because they are people that on a day-to-day basis are interacting frequently with people about financial matters. So it's really important that the people in financial services sector, for example, have a good understanding of what powers of attorney you can and you can't do, and issues around undue influence. I think one of the observations that I think our members would probably make is there's a real lack of understanding about how much, I mean, the one question, I suppose I put it this way. If you were to say, how could I best protect someone? If I'm doing a power of attorney, how would that protect me? Well, the answer really is, the only really clear answer is to choose the right person. And I say that because I'm sure, I'm not a financial advisor, I'm a barrister. In fact, that's really what I do. I'm sure my fellow lawyers here would say the court can only give us, and the law can only give a certain amount of protection, because there isn't complete oversight all the time of powers of attorney and people working with them. A lot of it does depend upon choosing the right person. So people having slightly more realistic expectations of what a power of attorney can do in terms of preventing financial abuse. In fact, many ways it actually adds to it. And the other is, I think a lot of the Solar members would say that there's an insidious element to financial abuse. And by that, what I mean is it starts off with, say, a family member who looks after mum's money or something like this. And they probably mean it very well. But after a while, they start to kind of think of it as their money. It didn't start off with any malice of forethought. They didn't intend to be bad people. But they talk about it, the parents say, when you die, it'll be mine. And there is a sort of transition that happens with some people where they do begin to think of it as theirs. And so they don't deliberately set out to abuse this person, but by the way in which they deal with that money, they do. And it comes up with financial advisors, of course, because when you're looking at, for example, investments and looking at with a power of attorney, of course, there's lots of legislation about that. But you obviously have to bear in mind that people are thinking about when I inherit it, as opposed to what the money is doing now for my parent or the person I'm looking after. So financial advisors are in a great position to start to see whether financial abuse might be gradually coming in, as well as identifying those people who start out with a clear intention of using people's money. And the other thing that I think is important is the bit that both of the other panelists mentioned around the interaction of a third party. Now, I was a founder member and for a long time a board member of Solicitors for the Elderly, which is now the Association of Lifetime Lawyers. We did have a really useful leaflet, which was called "Why Am I Standing in the Waiting Room?" And basically it was a leaflet to give people, to explain to them why it was really important that they were not, for example, there in all the interactions. Because that can be quite hard to say to them, because some of them genuinely are trying to help. So there's that kind of thing, is to try and identify where someone's over enthusiasm may be well intended, or it may not be, but that clear point that you do have to be able to differentiate between them being there to help and being there to actually help themselves. So I think we definitely see that with our members. Going back to things that we can do, and we've worked closely with Hourglass, is our nominated charity actually. But one of the things we do, we have a vulnerability module, which is free to use. You can find it on the Solar site. A few weeks ago, I think 15,000 people had done it. I'm not sure what the number is now, but about that. And if you want to kind of gentle into, foray into making sure you've got the key points around that, that would be a useful thing to do.
That's lovely. Thanks, Tish. And maybe we'll put that link onto the chat function for folk.
I will do, yes, and I'm speaking at the conference next week in Brighton.
Excellent, excellent. Okay, many thanks. And then we'll finish the inputs with Colin, who's going to take us through just 2 case studies, which we hope will generate some questions. And if I could remind folk, if you could put your questions into the chat function, we will address those after Colin's input. Over to you, Colin.
Thanks, Sarah. So the 2 case studies that I'm going to discuss are based on real situations, but obviously the names and some details have been changed. The first one is about Belinda, who shortly after the death of her husband, Belinda was contacted by Victor, a local man she had known of through his work for a few years. They started to speak on the phone regularly, and within only a few weeks, Victor had managed to move into Belinda's spare room because his ex-wife was putting him out. A few months later, the relationship had reached a stage where Victor asked Belinda to marry him. She didn't agree at first, but he asked several times over a month until she eventually said yes. Victor had found out that half of Belinda's home had been signed over to her late husband's son. And he also, Victor himself, had little income, relying solely on his state pension. So Victor became verbally abusive and aggressive to the point where Belinda would do everything he told her. Belinda would clean the house regularly to prevent Victor getting angry. She sought his approval on any purchases, even on basic grocery shopping. And she gave up hobbies and social activities because Victor didn't like her to drive. On occasions, Victor would even stand in front of the doorway to stop Belinda leaving the house. And within a year, Victor had asked Belinda to change her will in his favour and remove her own children from it. So that is the first case study. I'm not sure if any of the other panelists have any thoughts on that particular situation.
I mean, I'm happy to jump in very briefly. I mean, just applying kind of what I said about the factors and, the kind of things, specific kind of things we would look into. I mean, my thoughts when just looking briefly at that scenario is, firstly, we know Belinda, probably grieving after her husband's death, and that would tend to make somebody particularly vulnerable and, you'd say susceptible to coercion. And then in terms of what we know about the tactics that were used by Victor, he moved in, giving him the kind of the means and the opportunity to kind of exert as much coercion as pressure as he wanted. He isolated her, got her to give up hobbies, even stopped her leaving the house and things like that. He seemed to assume a kind of position of control over her, controlling kind of payments and her finances and things like that, making her clean the house. And what we know about the kind of method of coercion, it seems he was aggressive and may have kind of used threats of kind of abuse or harm to kind of get her to do what she wanted. And I mean, just from the fact that he asked her to marry, he kind of kept badgering her to marry him. It seems that might have been a kind of drip sustained type of coercion. Motive, he would benefit under the new will, so that's obvious. And I guess the two things we don't really know is, was a legal professional involved in doing the will? That would be very important to kind of see if somebody was, and if so, what their file said. And the final thing would be what possible explanation is being given for the change of this will. either by Belinda or Victor. I mean, it seems on the face of it to make very little sense that after knowing him for, properly for a year or so, she would kind of cut her children out entirely. So all I'd say is on the face of it, it certainly seems like there's grounds to explore a claim for challenging that will, say she passed away on grounds of actual undue influence, but we'd obviously have to kind of dig in a lot further to it.
I'd like to chip in as well. So if Belinda was to come to me and provide instructions to create a will, I'd obviously go through the existing will that she has, ask her reasons for doing so, and making sure that I see her alone in person. If it was Victor, for example, that arranged this meeting, then obviously that would raise red flags, and I would verify the instructions directly with Belinda on her own. It's also worth noting that I mentioned earlier, an unwise decision doesn't necessarily demonstrate incapacity. So she might have perfectly valid reasons as to why she's removing her children from her will. So she might no longer be in contact with them. So as a solicitor, I would obviously make sure that she understands the impact of her decision. So does she understand the information being given to her? Can she retain that information to make logical decisions? And does she understand the consequences of making those decisions? And as Tom said earlier, as there are clear signs of undue influence here, I must ensure that I create detailed attendance notes on the files and all the conversations and meetings that I've had with the client specifically.
Can I add a point in as well, Sarah?
Yes, certainly.
One of the things that occurred to me when I read the case study is actually Victor doesn't necessarily need to get a new will done, because the marriage would have revoked any previous will anyway. So, and the will that was in favour of her children has now been revoked just by the fact that he's managed to persuade Belinda to marry him. And that's one of the reasons when we're seeing clients, we always talk to them about the idea of not giving assets outright to a wife or husband, but putting them on a life interest trust instead. And that seems to have been done perhaps with the home, because that's been, well, they say it's been signed over to the late husband's son. But certainly if there's any mixed marriages, you've got children by one marriage and not the other, and you're really concerned about where the assets are going to go to, then not having everything pass out right to the person does give an element of protection from the kind of gold digger Victors of the world that move in, because there's nothing they can do if it's all tied up in a life interest trust in a previous will.
Okay, that's helpful. Thanks, Joe. Tish, were you wanting to add anything?
I need to say that I was going to say what Joe said about that exactly, the point about increasingly as well, as we're dealing with older people, because the demographics have changed. There are so many more people in that situation now where they have remarried and there are potentially conflicting interests. And so, as Joe said at that point earlier, looking at that possibility might well have potentially prevented that situation from being as bad as it could be.
Thanks, Tish. Okay, Colin, do you want to present your second case study?
Yes, thank you. So this one features Emma, who called the Hourglass helpline when she was concerned about her mother, Anne. Anne lived alone and near to Emma's sister, Sarah. When Anne needed some work done on her home, she moved in with Sarah temporarily. Emma soon discovered that Anne had been persuaded to grant lasting power of attorney solely to Sarah, where it had previously been agreed that Emma and Sarah would share this. Anne was not allowed to return to her home by Sarah. Sarah started to take payment from Anne for providing care, although it was unclear what this care actually entailed. It also became unclear as to whether Anne had the capacity to grant the lasting power of attorney in the first place. She said that she hadn't agreed to give Sarah money. Okay, so over to the other panelists if anyone has any views on that particular situation.
Yeah, I mean, I'm happy to jump in again very briefly, just with a few thoughts. Again, just kind of looking at the factors of kind of undue influence, I would consider the things that jump out is, concerns about capacity. Even if she has capacity, that would lead you to think that at the very least she's kind of vulnerable and elderly and maybe particularly susceptible to coercion. And then, in terms of the tactics, I've seen this in a couple of cases, the kind of classic thing of, a parent moving in with someone and them not then kind of letting them return home is, quite a classic thing. And, kind of being in the guise of a carer is again a classic kind of way of assuming control over somebody. Obviously, we don't know too much about the kind of circumstances of that new LPA being done, but what would be very important, and I'm sure Lee will speak to this, is again seeing if a legal professional was involved. And when you do an LPA, there's a certificate provider who's meant to kind of sign something essentially saying that they're happy the person knows what they're doing and doing it with their own free will. And so it'd be very important to find out who that was. Was it the GP or was it just some random friend of the daughter? And there's also, there's kind of different claims potentially relating to both revoking the LPA itself and relating to the kind of financial transactions that are being done, depending on whether or not there's a lack of capacity or whether or not there is capacity, but then there's undue influence. So there's a lot of kind of interesting things to explore, but potentially there's kind of grounds to try and revoke that LPA through the court of protection if you can show she didn't have capacity to enter into it or if she was coerced, or if the LPA is valid, the attorney would have at the very least fiduciary duties. If there's a lack of capacity, she'd still have to kind of do everything in the best interest of the mother and couldn't just pay herself money for care. And so even if there wasn't undue influence and she was just acting on the power of attorney, it still wouldn't be the right thing to do. So that, as I said, those are my kind of very brief thoughts, but there's kind of a lot to pick apart, I think, in that scenario.
Could I comment there, Sarah?
Yes, surely, Tish.
I think this sort of situation is really frustrating because there's a clear difference between the legal profession and the general public. And I don't mean that in any way badly. What I mean is we, for example, will be talking about the role of a certificate provider and things, and unfortunately with powers of attorney, and it's a controversial subject, which obviously is not the subject for today, about how much you should or shouldn't involve a legal professional in doing a power of attorney. And you can do them online and do them yourself. But everything is there for a reason, and a certificate provider is there, as Tom just said, is there in order to look and say, did this person do this freely? Did they have capacity? However, a certificate provider can be a general member of the public. And unfortunately, experience over the years of doing this would lead me to say that whilst when certificates providers came in, I remember us all being so concerned about insurance, what we would do, how we would certify it. A lot of the general public that act as certificate providers think it's very much just like being a witness and saying, yeah, okay, they understood it. So that it doesn't always give the protection that you would hope it would. And with regard to carers, I think it slightly involves what I was saying earlier about that kind of rather casual attitude that can lead to financial abuse, where one person just a family member, even it's my mother, just starts to almost deal with that money as though it were their own. And you do see that happen a lot, and it's a really unfortunate situation. And specifically, it's not directly on this case study, but it's around care. There is a form of financial abuse which is very insidious and which probably isn't even identified directly as that in the relation to care, which is family members who encourage their parent to stay in their own home not the guys, they obviously mean to. I'll help you, I'll support you, mum. You can stay at home, but probably don't give them the care they really need. And the reason is because if they were to go into a care home, then the house might be taken into account for local authority funding. Whereas if they stayed in their own home, the home would be disregarded. Now, that's very difficult to identify, but it is, in my view, quite, it's something that occurs. So they start off saying, well, if mum goes into a care home, the house will be taken into account. If she stays in her own home, it won't. And they mean to try and support them at home, but that support gets less and less. The older person themselves doesn't like to complain about their children. They feel guilty that they're even their children are even doing this. And so that whole thing leads to something where seriously, certainly we would identify that there are people who are staying in their own home way beyond when it's really what deep down they really want, while the children are saying, we're helping mum staying in our home is what she wants. Mum might have wanted that before she was very incapable, but she might not want that now. And that, to me, is a form of financial abuse.
Absolutely. Thanks for that, Tish. Lee, do you want to make a comment?
So I was just going to say that obviously the case study states that it's unclear as to whether Anne had capacity to grant the LPA in the first place. So as a solicitor, I would be ensuring that a reasonably qualified medical professional has done a mental capacity assessment in the first place, and also assess the mental capacity of the client. And she also mentioned that she hasn't agreed to give Sarah money so immediately. That brings issues of capacity as well. So she's unclear as she sits. She's unable to recall her previous actions. So I think it's always a case of ensuring that solicitors follow the golden rule in the first place when taking instructions.
Thanks, Lee. And Joe, would you like to make a comment on the study?
I was just going to say that I was wondering whether the removal of the requirement to notify people that you've applied to register an LPA has had the bad effect in this scenario, because it's meant that Emma hasn't been aware of what her sister's up to. Whereas previously she might then have been able to say, well, hang on a minute, I don't think mum does have capacity to put an LPA in place. Let's get that checked. But we are seeing this more and more of family members putting pressure on, trying to get an advantage for them, their side of the family, for their children. I've had one recently where, bizarrely, one of my clients had a phone call from a friend of hers saying that he'd been asked to sign a document, in this case a will, as witness for the mum, but he hadn't actually seen the mum sign it. And the will, the new will, was all in favour of the sister's family. And you think, oh, this is happening far too frequently. But I agree entirely with what Tish says. Often it starts with the best of motives. And then just as it goes along, I think it's just everything corrupts eventually. When you have access to someone's money, it's very easy to suddenly think, oh, I could just pay for my own stuff. I could just buy myself a handbag or whatever. And I think it's a slippery slope that people go down.
Yeah, absolutely. Thanks, Joe. Okay. Any final comments, Colin, or?
I mean, I would echo, some of what has been said there, that, these scenarios are very, very common. In fact, so we've cited 2 cases here, but that's 2 from very, very many. It's a huge percentage of the cases that come our way at Hourglass do involve financial abuse. We're talking 30 to 40% of our cases will involve financial or economic abuse. And often it does centre around some of these issues around capacity, around family members exerting undue influence over a parent, a partner, whoever it may be. So it is very, very common, and obviously this webinar today is really important because it's opportunity for everyone who's on the call and everyone who will be watching the recording to become more informed, to have more awareness of what to look out for and what to do about it.
Yeah, absolutely. Thanks, Colin. Just to, I hope the panelists maybe have seen in the question and answer box, but someone is asking if you could define the main characteristics which make people more vulnerable to coercion and undue influence, particularly in relation to creating a lasting power of attorney. And I don't know whether, Tom, you want to kick off with that?
Yeah, I mean, not sure about kind of a set definition, because each case is kind of individual. But I mean, the classic things you would see is somebody who's elderly, who's kind of reliant on maybe a child or something for care, or even picking up shopping or helping pay bills, and they're in that position of vulnerability because maybe their spouse has died and they're on their own. And obviously the other kind of side of vulnerability might be some kind of health issue or condition that maybe they're disabled or have mental health issues, or I mean, who knows? It's not kind of a set thing. It's just an assessment based on the individual circumstances of that person, in my view.
Yeah, no, absolutely. And I think you have outlined some of the areas that you would have probably in mind when undertaking that meeting with a client as a vulnerable person. And I think they're on your presentation. So that's a useful guide for people attending to maybe take a note of those. And it's just triggers, isn't it, really? It's being mindful to ask the right question. Any other panelists want to comment on that, or we can move on to some of our other questions, because I'm mindful of time. Just to say before we move to the questions, we've had a comment, as you will have seen in the question and answer box, from one of our Hourglass trustees, who is a geriatrician, pointing out that it is important that when people are seeking an assessment of mental capacity, that they do use a medical, and I can see Tish nodding, that they use a medical practitioner, because obviously someone who has had that extensive training and has those skills, as opposed to perhaps using a physician's assistant who would be under the mentorship of a medical practitioner. But to the general public, they would probably assume that a physician's assistant was well able to make that assessment. And it's this thing of really just raising that awareness with families, with older people themselves, how important it is to get the right person making the assessment. So thank you for that, Mary.
I just want to mention something, Sarah. The question was asking about defining main groups of people. I'm not sure that's possible, but there is, I think, a possibility of defining the most likely times when you're going to come across these types of issues. In our survey, when we sent this out and said, when is financial abuse most prevalent? 40% said it's when you're uncertain if someone has capacity or not. That's the biggest example. And then the one shortly behind it, 36%, is it's the person who's got authority, not enough checks on that person, whether it's a deputy or an attorney. So I think there are times when you can be more aware of these issues, even if the person themselves doesn't fit the characteristics you would normally expect to see. They're not recently bereaved, they're not old, they might not be having any kind of illness, but there might be other factors that make your alarm bells ring.
Thanks for that, Jo. And then one of the questions that we have is it possible to define the difference between undue influence and coercive control? And we know we often hear coercive control, the term used often in relation to domestic abuse situations. But I just wondered, is there a subtle difference? Does anyone like to comment on that? Tom?
Yeah, I'm happy to jump in again. I mean, in my mind, there is a kind of subtle difference in the sense of, just because someone's coercively controlling someone, it doesn't mean there's necessarily a claim for undue influence. What you would need for undue influence is for that coercive control to be, to a certain extent, and to then result in, the transfer of a property or money or a will. You need it to result in something you can then claim. And somebody could be controlling, for example, in the first case scenario, just because somebody checks all finances with them and makes them give up their hobbies. That's obviously terrible behavior, but it doesn't mean it's necessarily a claim for undue influence if it doesn't kind of lead to any loss, I guess, for them or their family, and as I said, in a kind of civil law sense anyway.
Okay, thanks,
Tom. I would agree with that. I would say it's completely the case. I think coercive control is a wider term, of which financial abuse is one aspect of it, because you can find coercive control as a key element, for example, in domestic abuse. although then that may not have anything to do with, you know, financial abuse as such. So I would say financial abuse is a very specific part. And as Tom says, the differentiator is where it results in some financial benefit to the person who is exercising that coercion.
Thanks, Tish. And then another question that we have, can you outline the role and function of the Office of Public Guardian, and at what point is a referral made? And I don't know, I mean, you're all well able to answer that, so whoever would like to step in first.
Yeah.
Tom's going to go again.
I'll jump in. I mean, I will caveat this by saying I don't do much court of protection work, and I'm sure if Lee, Joe, and Tish kind of have a better understanding. But I mean, my understanding of the OPG is that it's the government body that essentially polices kind of the actions of attorneys and deputies. But obviously, the drawback that Tish and Joe were saying is that they'll only kind of step in if they become aware of what's happening, and if somebody is keeping things completely secret once they're appointed as attorney, then they might have kind of no involvement or no because they're not going to kind of police everything in every deputyship or LPA scenario. So that is the kind of drawback. But once they are aware, they will step in and investigate things and potentially escalate things to the Court of Protection.
Thanks, Tom. And Tish, did you want to?
Yeah, I would say I was keep agreeing with Tom here, but Tom's absolutely right. And the key point comes back to what we've said. It's only if they know. And the fact is that the cases that Hourglass come across, the cases that Tom or Lee or Joe, any of us come across, are only the tip of the iceberg, aren't they? They're the ones that people find out about. So the OPG, I think perhaps my comment about them would be, there should be a little bit more understanding, education, just factual education about the fact that they exist and what they do, because they're not an organisation that the general public would necessarily think to contact, and yet they are contactable by the general public. You don't have to be a legal person to do that. So I think that's possibly the issue, that people don't know what they do. They will, of course, investigate. And then, of course, there is the other separate part of the Court of Protection itself, which can make orders in relation to financial matters, potentially of abuse and powers of attorney and things. So I think it's that. The other thing I think with that is, and I saw as a comment in a box somewhere where someone said SS Social Services, that there's also a bit of a lack of understanding around the fact that every local authority does have a system within that for reporting for someone who's responsible for vulnerable adults. And obviously this is not the subject today. I know Hourglass are doing a much longer one next week, but that only touches on the controversial bit. One about, as this person in the chat box said, I was in trouble over that. Basically, the fact that I'd identified them whistleblowing was an issue, and that's for the public, and for legal people, it's how does that sit? And there is good guidance on it from the Law Society, well, from the Solicitors Regulatory Authority. How does that sit with your duty of confidentiality?
Mm-hmm. Absolutely. Okay. Mindful of time, and we have a few more questions to get through in the webinar. One is, what training is available for professionals to help them understand the concept of undue influence? And is it mandatory, and is it accredited? And maybe, Joe, I know you did reference that in your presentation. Maybe you would like to address that question.
Sure, yeah. I mean, STEP does have training on this. If you're doing the STEP exam route to get into STEP, then it would be part of that. But if you're not, if you don't want to become a STEP member, or you're just interested in it, there is standalone training. And there is this advanced certificate in advising vulnerable clients that I mentioned. And that does actively teach people how to assess capacity, not obviously in a medical sense, but how to know when there are issues that you might need a capacity assessment. And is also, we have a will code and a code of conduct that we ask our members to sign up to, and that includes a sectional mental capacity. So we've tried, without making it mandatory, we've tried to thread it through everything, because it is such an important subject. And I know that the Law Society has something similar with its WICS program, which is its wills accreditation. So it is out there, that kind of training.
Okay, thank you, Jo. And then the next question, do many cases of undue influence come before the courts? And what penalties are typically imposed? And I'm thinking, Tom, this might be one for you to kick off with.
Sure. So I guess it's difficult to know exactly how many cases come before the court, because probably 95% of cases settle, and so you don't, they very rarely reach trial, and so you're not kind of aware a case has been brought at all, because there's no judgments. But I mean, just in my own experience, again, echoing what everyone said, obviously seeing a rise in the kind of inquiries that are coming to me and people seeking advice on this kind of thing. So I imagine whatever the number is, it is rising. And in terms of the penalties in the civil court, kind of as I touched on in my slides, the general remedy would be the parties being put back into the position they were in before. So if we're talking about money being paid back, if we're talking about a property being transferred back, and the other penalty would very likely be having to pay the claimant's legal costs, or a significant proportion of them.
Thanks, Tom. Lee, do you want to comment on that question?
I think Tom's echoed what I was going to partially say, but I think nowadays I think it's important for solicitors to try and prevent a claim for undue influence taking place. So if they follow robust processes, if they do detailed attendance notes, then it's very obviously easy, hopefully, to defeat a claim for undue influence and prevent it from happening in the first place. So yeah.
Okay, thanks, Lee. Tish, do you want to add anything, or?
No, only other than to say that the use of the word penalty, as was said here, there are remedies in the civil courts, and they may have financial implications. Because you said, the person said penalty, it just might be worth commenting that sadly there is not the overlap that you would hope or expect in criminal law for cases of fraud. For example, a lot of the issues around financial abuse would potentially give rise to criminal liability. I'd like to think that bit by bit the police are taking it more seriously, and they probably are more than they were, say, 20 years ago, but it is quite slow. And it's surprising how hard it is to get any police involvement quite often in matters which they would tend to try and say are domestic.
Yeah, okay. And I don't know whether panelists have had a chance to look at the comment in the question and answer, but someone is saying that it can be quite difficult to get the OPG to actually investigate, and often then families or whoever feel that they have to go to adult safeguarding, and difficult to actually to get action, I suppose, to resolve. But
yeah,
Jo,
I can comment on that, because I had exactly that case where a gentleman had died. We were going through the probate, and his daughter, who was one of the executors, suddenly realized there was a lot of money missing, and the only person who could possibly have taken it was the attorney, which was her brother, which was a very awkward situation. And of course, brother denied absolutely anything. There was no money missing. It had all been used on what it should have been used on, or been used on paying for care, but it was a very large sum. And when you started digging into the bank statements, you could see transfers going from the now deceased father's account to this son's account, and no receipts, no explanation of what these sums were for. And she did speak to the OPG safeguarding unit, and as has been said, it wasn't as good an experience as she'd hoped. They weren't as keen to investigate because she had no evidence, or very little evidence. She had evidence of money going, but she had no evidence that what he said, that it was all for care and it was all because it was required. That was the difficult bit. So it is hard. It really is hard, and it's even harder when you're accusing your own brother, sister, mum, dad, whoever, that family relationship. And I think a lot of people just give up. I think a lot of people just push it under the carpet and say, well, it's done, dad's dead now, there's no point looking at it.
Yeah. Absolutely. Colin, is there anything that you would like to comment just from your experience through Hourglass and community response?
Yeah, so I think I would say similar to what Joe has just said, that I think sadly people do become I think a little bit jaded with the process when they, particularly in that scenario where the victim is deceased, it almost does become at times a case of, well, you know, nobody is suffering anymore in this situation, so you know, is it really worth continuing to pursue justice here? And that sadly is something that people do, I think, experience. And yeah, generally, I would say that, you know, anecdotally, from our work, that where the victim is deceased, it does become difficult to engage the officer of the guardian in that process. And you know, like many services and organisations, they are of course limited in terms of their resources, but perhaps not as limited as the victor that we're seeing here. Perhaps they're not as limited in terms of their sort of protection. There perhaps is more that they could do where they more appropriately do it.
Okay, thanks, Colin, for that. Now, an interesting question. If we wanted to raise awareness of undue influence, and I think from what we've heard this morning, it's obviously something that needs further awareness raising. What should a campaign look like, and what are the key messages, and who is the target audience? And maybe Tish, you would like to, from your experience, what would a campaign look like to raise awareness, and what would be the best way of promoting that to the public?
Big question for in one off the top of my head, but I think and marketing people would probably know much better, but I do think there's probably two distinct audiences, because one, there's the policy part of the campaign, which would be the government-centered, you know, social policy, raising awareness of one, of the importance of it, and secondly of the fact that we do have systems, but as been identified here, just as with everything, they're not perfect. And so people can become disillusioned if they use the system that doesn't work. So I think there's that public policy bit. And then I think there is the general public part bit, which, how do you do that? A huge national publicity campaign won't help, because you see how much money it costs to put something on television. It's gone in just a flash. You know, and that's not going to be realistic. So it's more going to be, I think, through the kind of things you're doing here with organisations, raising awareness across other not-for-profit and charitable organisations, and making that readily available, of explaining that this is something that is an actual matter that can be dealt with. Because I think an awful lot of people think as well, it was just a really bad thing that my family did. They don't see it in the context of actually being financial abuse. They don't give it that name. So one of the things I would say off the top of my head is calling it out for what it is. This is not just a bad thing. This is actually financial abuse. I think that term itself is not used enough to identify what otherwise is sometimes people get away with as being poor behaviour. Yeah,
absolutely. Joe, would you have any comment to make?
Yes, I mean, I would. I think part of the education, as Tish just said, don't try and do, you know, a campaign or TV or news ads, but try and get some of the programs that are on, consumer protection programs that are on TV and on radio involved. They've suddenly got interested in the probate delays, because that's a big topic, and a lot. It's partly, and I know this from personal experience, it's because the people who run these shows now have personal experience of a probate delay somewhere in their family. So if any of those people ever had experience of this financial abuse in the family, you could get them to then run a program about it and to explain to other people, and that would reach a far better audience, I think. And the other thing is, as I noticed, there's a question come up about financial firms also being very reluctant to report suspicions of financial abuse unless they've got clear evidence. And STEP is part of something called the Vulnerable Banking Group, which is trying to work with banks and financial organisations to help them how do you deal with vulnerable customers? And we've got shocking evidence of people being marched into a bank and taking all their savings out, and nobody raising an eyebrow. But if you're trying as a professional deputy or professional attorney to register that you are now authorized to deal with that account, it can be really difficult to get access to those money, and you need it urgently to pay for the care. So there's a massive mismatch here between what we know should be happening in practice and probably what the bank policies say, but what actually happens in the branch on the high street. Right. And so that's another thing that we're working on and trying to educate.
Okay, and that's useful, Joe. Tom or Lee, any thoughts on how we raise awareness, or with whom should we be raising more awareness?
Yeah, I mean, I agree with everything that's been said, and obviously, events like this and the conference next week, I think are the best way to do it. I mean, I come in when there's already been a problem, so it's quite difficult for me to kind of say what should be done. But obviously, the best thing a solicitor could do, particularly in kind of Lee's position, as he said, is just do follow the golden rule and kind of do everything correctly and take a clear note. And that really is the best way to kind of mitigate further issues down the line and prevent them at an early stage. But obviously, the problem is that, as we said, people don't see a legal advisor if they're trying to kind of push someone to do something, and that's the problem. It's the same with the OPG. If someone's doing something behind closed doors, how do you stop that? And the target, you would expect, the kind of target audience should really be the people at risk of being abused. But having somewhere like Hourglass or somewhere that they could contact if they feel that something wrong is happening or they feel scared. But obviously that again relies on them actually making the call or that, and maybe they're too vulnerable to actually or maybe the phone's being kept away. You never know. I don't think it's possible to 100% do it, but the more it's talked about, the more might be prevented.
Absolutely. Colin, anything that you'd like to add in terms of, I mean, obviously we know that one of our goals in Hourglass is to campaign on certain issues, and just from what you've heard in relation to this area, any thoughts?
Yes, so I think this is one of those things where I think there is, as Tom has just pointed out, there are some difficulties in that often these things only come to light after the event. And what we want to do, a big part of what we are about at Hourglass, is preventing, stopping it from happening in the first place. And really, the only way that can happen is through raising awareness and through that sort of education of everyone, because it's up to all of us to be aware and alert to these situations. Obviously there will always be, sadly, unscrupulous people who will try to exert undue influence, who will try to make financial gain out of someone they perceive as vulnerable. However, I think the majority of people recognise that shouldn't happen and that is wrong. So the more awareness we can raise about first of all, that this is actually a thing, and as Tish said earlier, it's not just someone misbehaving, it's actually somebody perpetrating harm on a potentially vulnerable person, often a family member. So I think one of the ways, again, that's been mentioned already is where somebody has had that experience, they already recognise that this is a thing. If we can tap into those places where those people have a platform, where there is a position of they're in a position of being able to sort of broadcast the message or shine a light on it, such as people who are working on consumer programs on TV or radio, the more information we can get out there about this, and just continue to raise keep it in the conversation, and try and build the public consciousness of this, that first of all, it is something that happens. Secondly, it's something that should not happen. Are steps that can be taken, and there are processes available to prevent it and to tackle it if it does happen.
Yeah. Thanks, Colin. And we've had, as you've probably seen in the question and answer box, someone quite rightly saying that the obvious target audience is to older people who still have capacity to make them aware just of the issue of undue influence, and using organisations like the, you know, Third Age, where older people who, yes, have retired but are still very active and outgoing, to spread the word. So I think that's quite good. And I'm not sure, Colin, how much contact Hourglass has with similar organisations, but it's something we can take away and possibly look at going forward. Just then, for our final question, and I'll just do around Robin really with this one, and if you want to address this question or any closing comments that any of the panelists would like to make from this morning's webinar. And that is really, how can all sectors work together to raise awareness, as we were talking about in terms of campaigns, to educate, but most importantly, ultimately to prevent undue influence going forward. And Joe, just because you're first on my screen, if you maybe want to comment on that.
Yes, and there was a question in the box as well about, I know, how do we share resources, and is there a kind of list of questions that you can have in front of you? I know Lee's been talking about the golden rule and about making sure you keep file notes, but there are certain things that should be ringing alarm bells when you meet somebody, and it is common sense. It isn't magic. And I had one client come into me who suddenly, out of the blue, wanted to change everything to give his property away to one son. I knew he had a son and a daughter, and he just wanted his property to go to one son. And he had a little piece of paper with him, this client, and he kept reading it. And I thought, well, someone's written that for him, haven't they? And he just keeps reading this paper. So eventually I asked him if I could take the piece of paper, and I put it in my book and closed my book. And I asked him what he wanted to do, and he couldn't remember. Without that piece of paper in front of him, he had no idea. And he was talking about giving his property, whole property away to his son. And I started talking about, well, how are you going to pay rent? And he said, who's going to pay me rent? No, it'll do this. It was quite clear he didn't have capacity, or there was undue influence, or both, probably. Yeah. So I think there are things that you can do. And maybe if you've got a will questionnaire that you run through with clients, you can have a couple of things on that about, do I think that they are actually doing this themselves? Do I think that there's anybody else influencing them? Have they mentioned the same person again and again? You know, my daughter wants me to do this, my daughter wants me to do that. You can start having a picture. And I think we've all got the skills already. It's just a question of awareness and making sure we put those in practice.
Thanks, Joe. Lee?
Yeah, so I think obviously the Hourglass conference next week will enable everyone to sort of get together and share their views and experiences, and attendees there would benefit from that. Also webinars like this that we're doing today, and also law firms as well. I know Anthony Gold have a very good selection of blogs that solicitors do. They also have YouTube videos as well that people can view, and also trying to make use of the digital world, so podcasts, YouTube videos, TikTok, those kind of things, to try and get people engaged and raise awareness for this sort of issues.
Thanks, Lee. Tish?
Yeah, all of the above that everyone has said, I think is absolutely, because it is about education. And I bet the bit we don't join up enough, but it's just how it's very difficult to do, is STEP have fantastic resources. Not all of them, you'd have to be a STEP member to come, you know, you can come along to them. Obviously, Law Society, loads of solicitors do them. The Association of Lifetime Lawyers, which was until recently Solicitors for the Elderly, does a real huge range of courses. There again, you can come if you're not a member. It's just spreading the word. Society of Later Life Advisors, we have an ongoing program all the time. It's on our website. A lot of them are free, even to non-members, just because you want to spread the word. But I suppose the other thing is what you said at the beginning, Sarah. Because at the beginning, you said to the people coming today, and if you're listening to this, and you've got colleagues or friends you think would benefit, then please share it. So I think that's a really important thing to remember, that all the things that are done, it's very important, if you've found any benefit from them, to share that. And you know, with social media now and everyone's ability to make, you know, media communications, that I think will make a difference, because if everyone today shared this with one person, that, you know, that would be really helpful.
Absolutely. Many thanks, Tish. Colin, any final comments from yourself?
Yeah, just, you know, again, to echo what everyone has said, that you know, there are great resources out there, and even activities like this particular webinar, like the conference next week, that Hourglass is running, but also often it is that people just don't know where to turn, where to start with these things, and that's one of the places where we at Hourglass do come into our own very often, because people will find our number, they'll contact us, and that's the first step towards being pointed in the right direction of the support, that, you know, the appropriate support. So, for example, through things like our Give an Hour scheme, and other signposting and referral pathways that we have, we are able to kind of bridge some of those gaps so that people get from the crisis that they are in to the support that they need.
Thanks, Colin. And then last but not least, Tom, for a final comment from yourself.
Sure. I mean, I agree with everything that's been said. You know, the important thing is obviously getting the message out there to try and make people aware and nip these issues in the bud before they kind of even become issues. I mean, the only final thing I would add from my perspective as someone who said people come to it when these issues have already happened, and I then look into what's happened. If you are, you know, in the position of, you know, a relative who's concerned that somebody else is abusing your parent or something like that, don't just ignore it, because again, evidence to prove these things is difficult at the best of times. So the more kind of this is raised at the time it's happening, the more messages there are, you know, potentially. And I've had this, and, you know, maybe it's not always in the best taste, but if you're really concerned, record family meetings or interactions, so you've got that kind of bank of evidence when it's needed. But the more there is around this stuff at the time it's happening, the easier it is to deal. You know, obviously it's best to prevent it then, but if it can't be stopped then, if you want to do something about it later, the more evidence you've got of what has happened from that time, the better, because, you know, you're already kind of fighting an uphill battle when it comes to that point.
Absolutely. Thanks, Tom. We're obviously come to the end of the webinar. The 90 minutes goes in quite quickly when it's such a complex subject to address. And I would just like to finish the webinar by expressing sincere thanks to all of our panelists this morning for shedding so much insight into this very complex subject. I hope all our delegates have learned something. I certainly have. And I would also like to thank our panelists for giving so generously of their time this morning. Just before closing, can I remind everyone to please complete the questionnaire, the SurveyMonkey questionnaire, because we do act on any feedback that we get back from delegates who have attended. And I'm almost afraid to say it because our panelists have been very good in mentioning the conference, but once again, just to remind everyone that our conference takes place next Tuesday in Brighton, and there are still places available. But if you can't make it to Brighton, please do consider perhaps joining us virtually online. And I know Naeem has already uploaded the link for that. So thank you all very much for joining us this morning, and a special thank you to our panelists. And I look forward to, I hope, lots of you joining us again for our next webinar. So keep an eye out on the newsletter and across social media outlets for the date of our next. And for those, I look forward to meeting those who will be there in Brighton on Tuesday at the conference. Take care, everyone, and thank you.